So picking up with African Americans and civil rights. As I said at the beginning of the other video, if you take a look at African Americans and their method of accomplishing or achieving equal civil rights, has really been the model that other groups have used to gain civil rights as well. So we'll look at them, and then it's easier to follow what's going on with the other groups, and you can just see the individual points in the other group's history, but they're following the same approach. So African Americans were brought over to America as slaves. So this discrimination had run deep for 250 years. And then something terrible happened. So they were literally brought over about 1620. The first 20 African Americans came to what would become the United States in about 1620. And then in 1857, something happened that put the stamp of approval on slavery by the Supreme Court. And that was in a case called Dred Scott versus Sanford. So what had happened was a black man who was a slave came to a free state. And he argued that since he was in a free state, that he was now free. And the Supreme Court said no, that is not true. In fact, they went farther, that a black man, free or slave, was chattel, meaning property, and had no rights under the government. Furthermore, in this Dred Scott versus Sanford case, the Supreme Court basically held that the Missouri Compromise was unconstitutional. If you remember from U.S. history, what the Missouri Compromise was a compromise between certain segments within Congress and the North and the South about what states would be free states and what states would be slave states. And the North, of course, wanted all of them free, and the South, of course, wanted all of them slavery. So they compromised in what became known as the Missouri Compromise. For every free state that was admitted, Congress would also admit a slave state. And the Dred Scott versus Sanford decision of 1857, in essence, declared that the Missouri Compromise was unconstitutional, that you couldn't restrict slavery. So the Dred Scott versus Sanford was one of the causes of the Civil War. It helped to result in the Civil War. Let's see, next slide here. Why isn't it going? Let's try it again. There we go. Okay. Eventually, with great cost, about 600,000 Americans dead, the Union gets victory over the South. And with that victory came the ratification of the 13th, 14th, and 15th Amendments. The promises implicit in these amendments were first honored and then broken in subsequent eras of Reconstruction and segregation. So Reconstruction is that era in American history after the Civil War where we bring the southern states back into the Union and are trying to teach them, quote, how to be good individuals, how to treat all people with equality. So that is Reconstruction. So the 13th Amendment ended slavery. The 14th Amendment granted citizenship with its associate rights, and the 15th Amendment guaranteed the right to vote. But remember what we've just said here. They were first honored and then broken in subsequent eras of Reconstruction and segregation. So there's this interplay going back and forth. Just because you have the South losing the Civil War and Congress passing these amendments doesn't mean that individuals within the South, their attitudes and their beliefs and their dispositions have changed. It took time. It took time for that to happen. Many would argue that it is still taking time. All right. So honored. This is what was happening initially with Reconstruction. So that period after the Civil War, when the South was occupied by the federal government and trying to teach them what it meant to be, quote, a good state and to treat people with equality. So many African American men actually stayed in federal offices because the North is in there making sure that they have the right to vote, making sure the South is not discriminating against them. There was the Black Caucus within Congress, and there was the gradual elimination of black code, meaning laws specifically designed to discriminate against blacks. But then something happened, and that was Plessy versus Ferguson. But we'll get there. So movie theaters. So this is not everything was even in this period of Reconstruction. Not everything was as equal as you might think, based on what we've said here. Movie theaters had to be racially segregated, even during this period of Reconstruction. In 1883, so only about 20 years after the Civil War is over, the civil rights cases basically declared that racial discrimination in hotels was legal. You could have black hotels and white hotels, and that was okay. And the reason they said that was because this was these hotels were private groups, not the government doing that. That is why I said at the beginning, going all the way back up to the slide up here, let me find it. Policy is designed to protect people against arbitrary discriminatory treatment by the government officials or individuals. So that's what it would eventually become. So as you can see right here, at this point, it was not against individuals. But then what happened in 1896 was a complete catastrophe. In a case known as Plessy versus Ferguson, it was about segregation in transportation. So it was specifically dealing with railroad cars. And it was permissible, the Supreme Court said, was permissible if the separate facilities were substantially equal. So Plessy versus Ferguson created what's known as the separate but equal doctrine. Separate but equal doctrine, which says that blacks and whites could be treated differently or required to use different facilities if the facilities were substantially equal. Okay, that's what's going on. So I hope you can see this very well. So let me give you the background of this Plessy versus Ferguson case. Okay, that should be in italics. Okay. So here is Homer Adolph Plessy. You can see that right there. Here's Homer Adolph Plessy. Make that a little bigger. All right. Homer Adolph Plessy. He reasoned that he could sit on the white railroad car. After all, he reasoned he was more black than white. So here is a genealogy chart of Homer Adolph Plessy. And so this would be his father, this would be his mother, this would be his father's father, and his father's father's father. This would be his father, his father's father, and his father's father's mother. So if you look at this, okay, if Homer Plessy is saying, I'm more white than I am black, why is he saying that? Well, his father's father's father was white. His father's father's mother was white, making this guy white. And then his father's mother's father was white, and his father's mother's mother was white, making his mother white and making his father white. Over on his mother's side, his father's father's father, or let me back up here. So yes, his mother's father's father, white, his mother's father's mother, white, making this guy white. His mother's father, white, his mother's mother, African American, making his grandmother half white, making his mother a quarter white, making Homer Adolph Plessy, 1/8 African American. Now, here is a picture of Homer Adolph Plessy. And as you can see, he looks like, quote, a white guy. Now, it is a black and white picture, but he looks pretty light-skinned. And he seems to have the characteristics in common with many whites, right? Whatever that means. So that's what he reasoned. But according to Louisiana law, an individual could be no more than 1/64th black and still be considered white. So looking at this, in order for Homer Adolph Plessy or anybody else to be considered white, their father, grandfather, great-grandfather, great-great-grandfather, great-great-great-grandfather, 4 great-grandfathers back, this generation, only one of them could be African American in order for Homer Adolph Plessy to be 1/64th black. That would make him, if he was at most 1/64th black, then according to the eyes of the law in Louisiana, he would have been considered white. So you can see here the intent is not really, the intent is to keep the races separate. They didn't want them intermingling. And was it because they just wanted to keep the races pure, both races pure? Clearly that is not the case. They were more interested in, quote, keeping the white race pure. And if that sounds offensive, I completely understand why it sounds offensive, but nevertheless, the only thing that would be more offensive is not to say what happened, not to say what they're thinking, and not learn from the mistakes of the past. All right. So in this, you're living in this era. So 1896, Homer Adolph Plessy is established, and it creates a system where the governments can legislate and have this two-tiered system of equality. And of course, African Americans who wouldn't didn't like this, and so they needed a strategy to try and change the law, but also to change society itself. Now they could have done this. They could have done this in two ways, and in fact, they pursued both simultaneously. But at first there was more success in the courts. So they could have pursued a legislative strategy, which they did, but it was hard to get success in a legislative strategy when you still had a majority of Americans having inappropriate views, discriminatory views against African Americans. And so they also pursued a judicial strategy in which they only needed to get a majority of the 9 Supreme Court justices to agree with them to start to achieve some equal civil rights. So it's odd, but the civil rights strategy, the court strategy, initially pursued a path that seems completely odd. They asked the Supreme Court to enforce Plessy versus Ferguson. Now, you think, what the heck are they doing? Enforce a racist court decision? Well, remember what it said. Plessy Ferguson said that the facilities had to be equal, substantially equal. So it creates this separate but equal doctrine. So these black civil rights movement is thinking, okay, there's our opportunity. If we can show that certain facilities or certain practices are not equal, we can get the court to change them. So in Gaines versus Missouri in 1938, the Black Civil Rights Movement goes to the Supreme Court and asks them a very simple question. So in Missouri, there was no black law school, but there was a white law school. Remember, the facilities had to be separate but equal. And there just wasn't a black law school. So a black guy tries to get into a white law school, and he's told no. And so in Gaines versus Missouri, the civil rights, the NAACP takes this case and says, let's see what the Supreme Court will say. And so they're basically asking the Supreme Court, does 0 equal 1? separate but equal. Does zero, no black law school, equal one white law school? And the court said no. Admit him. Admit him. Okay, now, this was a slow process. It didn't happen quickly. Okay, so Plessy versus Ferguson is 1896. Gaines versus Missouri isn't until 1938. Then in Supple versus Oklahoma, the NAACP, Civil Rights Movement, right, simply asked this question, another law school question. Does a future black law school equal a current white law school? Future one, so now there's going to be a future black law school with a current white law school. Well, in algebra, you know that if this is zero, because there is no black law school right now, 0 times 1 equals 0. And we know that 0 does not equal 1. Therefore, the Supreme Court says no. No, it does not. Admit him and admit him now. And so then what happened with Oklahoma, they said, okay, since we don't have a black law school and we better do the same thing for other schools in higher education, what they did was they took a line and they literally drew it all, they literally drew it all over campus. Okay, here, come on. Okay, they drew it all over campus, and black stayed on one side and white stayed on the other. When it came down to the library, if you guys are too young to do, probably to have done much research in the old library, everything's now online. But one of the things that you found when you used the library, you'd go to the card catalogs, look up a subject, and you might find a book that you were interested in the card catalog, but they would put similar books in that same part of the library. Part of your research was really accidental almost. You'd go to that area of the library and those shelves, and you'd look at other books, and that's where you're finding information. So where blacks were concerned in this McLaurin versus Oklahoma state regions, they had to go to the basement of the library. There was a counter there. They tell a librarian what they wanted, and the librarian would go get it. But there wasn't that serendipitous kind of experience in the library. And so the court said no, different treatment to students solely because of race is unacceptable. So you can see here the NAACP, the Black Civil Rights Movement, is making success. You can't treat them differently. You've got to give them equal access. All right, so they were having so much success, the Supreme Court, the NAACP decided to go for broke. You can see in these previous cases, they were in college. Here they decided, let's go to elementary and secondary education. At the time, now this was a slow process. At the time, in these cases right here, there weren't a lot of people going to college. So this was a slow approach. They wanted to change society, but you've got to change society slowly. Here they're kind of going for broke, and there was some division within the NAACP if they should actually even do that. The dilemma was the South was making progress, and if they tried to get the Supreme Court to overturn this idea of separate but equal and failed, they might reaffirm Plessy and set the Black Civil Rights Movement back. But they decided to go ahead with it anyway, and they go ahead with it, and the Supreme Court agrees and declares that segregated schools are unconstitutional because they violated the 14th Amendment's Equal Protection Clause. Now, they used a social science approach to overturn Plessy versus Ferguson. They said, this is what they said in their ruling. The separation had a detrimental effect upon a colored child by generating a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. And so that's what they said. And obviously, based on that, this violated the 14th Amendment's Equal Protection Clause. What is so one of the things that is almost unique, of course, unique has the connotation it's the only one. But the Supreme Court overturned Plessy by name. The Supreme Court, Brown versus Board of Education, overturned the Plessy by name. They said the name of the case in the Brown decision, said, we are overturning Plessy versus Ferguson. That is very, very rare that the Supreme Court will overturn itself and do so by name. Usually what they do is they carve out an exception and say why this case is different from the others and has now got to move this way. But in this instance, they overturned Plessy versus Ferguson by name. Now, if you've ever heard of the name Thurgood Marshall, this is Thurgood Marshall here. He was the lawyer who argued many of these cases for the NAACP. He would become the first African American to sit on the Supreme Court. All right, so you end segregation. And again, just because it's ended legally does not mean that attitudes are changed overnight. So to overcome this culture of segregation, the Supreme Court did a couple of things. First of all, they took over many school districts in the South. And they assigned students to schools that would promote racial integration. So in other words, just where you lived wasn't good enough. If the schools were still predominantly one race as to the other, that's not going to fly for the Supreme Court. And so they really took over. Of course, they had some administrators doing this, what was going on. And they ordered busing. They ordered busing to accomplish this. Now, this busing was actually taking place throughout the entire nation. In some places, obviously, more than others. Okay, so there are really two types of segregation. Segregation by law is known as de jure segregation. So these are the Jim Crow laws. These are the laws that were specifically designed to limit African Americans and their rights. Then there is this de facto type of discrimination, which means in reality. So, for instance, think of where you went to high school. Chances are it had one race more than another race, but really the reason it did so was because of housing patterns, just where people lived. So if you lived in a quote more white area or more Hispanic area or more African American area, was your school predominantly one race as opposed to another because of discrimination, or was it just in fact the reality of where people live? That is de facto. But even the court said this de facto is not good enough. You just can't claim that your school is predominantly one race as opposed to another because of this, and that's why they ordered busing. Okay. Now, so in this, you can see that the Supreme Court has made lots of inroads with respect to how individuals are being treated, and they've done that through the courts. They also, at the same time as we were saying, they took a legislative approach. And as things began to change, and as they got more allies in the legislative front, and they began to use this civil disobedience to gain support, they tried to end racial segregation that way as well. And so this is both politically and economic sectors. In other words, if you're doing sit-ins and marches and freedom rides and you're hurting businesses and you're raising all sorts of publicity that does not look good, it had its impact. And that led to the passage of the 1964 Civil Rights Act, the first Civil Rights Act basically in 100 years. And that had a number of beneficial, positive impacts on particularly for life for African Americans and eventually for all races. So it banned racial discrimination in public accommodations. So there was no longer hotels couldn't discriminate because they're not the government. So in housing as well. So forbade discrimination in employment on the basis of race, color, national origin, religion, or gender. It also created the Equal Employment Opportunity Commission to enforce protections against job discrimination. So there's some real teeth coming out of the 1964 Civil Rights Act. It was designed to overturn Jim Crow laws that had discriminated against African Americans for centuries. And so that's what's happening. So you got the 14th Amendment saying African Americans are citizens and they have rights, and that was in the 1870s. So now 1964, now you're getting some specific legislation to, in a sense, put that into practical effect. That is what happens, and it happens because African Americans are beginning to get more allies in the legislature because they demonstrate their lack of equal civil rights through these tactics. All right. In addition to that, they also get some voting rights that are going to come. Now, early on, voting for African Americans was restricted. What you have in the United States, when the Constitution is created, the requirements were white male property owners. Again, this was an improvement. This was an improvement to what it used to be. It used to be the aristocracy. Before that, not even the aristocracy. So change takes place slowly and incrementally. All right. So, but after the Civil War, you get the 15th Amendment, which was passed to extend the vote to all males. All males. So women still can't vote. And initially, as we said early on, that blacks had this right and they were exercising it. But then with the end of Reconstruction, you have the Jim Crow laws coming back, and that's what happens. Okay, so once the 15th Amendment is passed, these broken promises, and the reason they were able to be broken is because the South passed a number of laws which prevented blacks from voting. So literacy tests required an individual to prove that they were literate in order to vote. And there was a literacy test given, and it was applied discriminatorily. If you were a white, you might not have to take it. If you are a black, you would have to take it. And most of the questions could be answered in one of several ways. And the examiner could just, whatever way you answered it, even if you could read, he could argue that you missed it because there were multiple answers possible for each question. In addition to that, there were poll taxes. Poll taxes were, and there is a logic to this, just like there is a logic to literacy tests. The logic behind a literacy test is an individual ought to be able to know how to read in order to vote. First of all, they've got to be able to read the ballot. And in those days, most of the political information that was coming out printed. And so how are you going to know about candidates or issues if you can't read? So that's the logic behind literacy tests. Poll taxes, it cost money to hold an election. Shouldn't individuals who are participating in that election be required to help pay for it? That's the logic behind a poll tax. Problem was, again, it was applied discriminatorily. Blacks were made to pay the poll taxes, whites weren't. Then there was also what is known as the white primary. So when we get to elections, this will make more sense. But in order to vote in an election, there's usually two elections. You have the primary to decide who will be the party's candidate, and then you have the general election. So in the South, only whites were allowed to vote in the primary. Therefore, who's going to be a party's nominee? A white person. They argued that it was not discriminatory because anybody could vote in the general elections, and therefore it's not discriminatory. But they don't have a real choice when they can't vote in the primary. Furthermore, they really couldn't vote in the general election anyway because the literacy test, they failed them because of discrimination. And poll taxes, that was very difficult for the new free man to pay the poll taxes Um, they were required at a time of year when the sharecropping farmers, which most former slaves were, had not received their money from their sharecrops yet. So it was very difficult for them to pay them. Furthermore, even if a black could pass the literacy test, could pay the poll tax, the grandfather clause revealed that it was all a lie. It was all just a clever ruse. What the grandfather clause said was if your grandfather had voted in 1868, you didn't have to pass the literacy test. You didn't have to pay a poll tax. And whose grandfathers could vote in 1868? Whites, not blacks. So what happened was the Supreme Court would eventually kill these. So in 1965, the Voting Rights Act abolished the use of literacy tests for anyone who had completed the 6th grade. Now, it didn't get rid of it altogether, but it's never come back. It's never come back. So you can see here, even within this, there's an admission that there is a logic to the literacy test. The problem was it was practiced discriminatorily. In 1964, the 24th Amendment prohibited poll taxes in federal elections. And then in 1966, the Supreme Court voided them in state elections. And the Supreme Court declared that white primaries were unconstitutional in 1944. You've got to let everybody vote in primary elections that you let vote in general elections. And so there's this slow process to overcome the discrimination that blacks had suffered. And the approach is, again, what did I tell you at the beginning? What approach did they take? They took both a legal strategy and they took both a legislative strategy. And now, does this suggest that after 1965, blacks had all their rights? No. But that was the genesis. That was the beginning. And they have continued to progress and get more and more rights. Now, what has happened with other groups? They have followed that same approach. They have followed getting court rulings that support their civil rights. Once they get more support in society, they have been able to get legislation passed, which gives them those legislative rights. So you take a look at the LGBTQT group. Same thing. They used the legal approach and then the legislative approach. And basically every group has taken that same approach. All right, so I hope this has been helpful. Hope things are going well for you. Remember to email me, as always, if you have questions or concerns.